But you have to be conscious of the fact that if you're going to change the classification of a foreign entity, you have to be extremely careful, because the very fact that you change the classification of the entity could result in huge, absolutely huge tax liability to your clients. I'll give you an example from my practice. My client owned a Polish partnership. How do I know that it was a partnership? One of the owners did not have, any guess? Limited liability, that's right. So it was a Polish partnership. He was the 55% owner of the company, okay? He also owned a Polish corporation. He was a 98% owner of it, okay? Controlled foreign partnership. My client was a US citizen. Controlled foreign corporation. As a result of a change in local Polish laws, they decided that it will be a good idea to switch this company to a corporation, sorry, to partnership, and this company to a corporation. This was real estate. Oops, sorry, my handwriting is not the best. Real estate, and this was trade. In reality, this partnership almost didn't do anything directly. That's it. But most important for our purposes, they were switching this. So they were switching exactly the opposite, the corporation and the partnership. In this case,
I'm sorry, you talking about switching to a U.S. corporation and a Polish partnership?
Polish partnership to a Polish corporation, and a Polish corporation to a Polish partnership in the same country, everything outside of the United States. This company did not have any built-in gains. It was a trading company. It didn't really have, except inventory, didn't really have any assets of importance. This one had real estate, and then as you can imagine, and this was a real estate development company. So there was a built-in gain here in the assets. For the purposes of US international tax law, what happened here, by the way, this happened on the same date too. So what happened here is Polish partnership contributed the assets in return to the corporate shares and immediately dissolved, distributing the shares of the corporation to taxpayer, okay? A US citizen. In this case, there was no tax liability. They could have been, but it's a different, in this particular partnership, let's just, for the moment, say that there weren't any, there was no tax liability, but there is a potential for partnership distribution to result in actual gain. But in this case, nothing, no tax consequences. In this case, what happened for US tax purposes is the corporation distributed all of the assets to its shareholders at fair market value. So there was big gain here. And then the assets were treated as contributed into the partnership at fair market value. On top of that, this is a controlled foreign corporation. Later you'll learn, just toward the end of my presentation, that since this is a CFC controlled foreign corporation, subpart F rules kicked in and prevented the gain from being treated as a capital gain. There were other strategies that I utilized to lower the tax liability, but that's a different point beside the view. When I first looked at it, I saw this. When I took it a second time, then that's, you start working on it, that's a different story. But you have to be very conscious of the fact that when you check the box, it's not, it's not as if this is some insignificant event and you just check the box. It's a real dissolution of the entity and a real creation of another one. Even though I should mention that in both cases, under the Polish accounting, they did not do anything to distinguish the Polish account for the pre-dissolution accounting from the post-dissolution. For them, for Polish purposes, it was a change of name. In both cases, with no tax consequences whatsoever. They did not treat it as a taxable event at all. So obviously he had Polish tax advisors, and they said, no problem, let's switch it. It's going to be pretty good for you, but he never took into account the fact that as a US citizen, he's taxable on his worldwide income, and he would be taxable very much on this, even though it never left Poland. And even though under Polish law, it didn't mean anything.
So the moral of the story is that if our clients are US owners and they're fooling around with changing ownership structures on foreign lands, they should talk to you first.
That's a good morale.